Good morning, dear colleagues. We start our working day at Ukraine Crisis Media Center. The topic of the first press briefing is who is interested in blocking anti-rader bill. Our guest, Pavlo Moroz, Deputy Minister of Justice of Ukraine. Welcome on stage.
Доброго дня.
Good afternoon. Pavlo Moroz, Deputy Minister of Justice of Ukraine, on state registration, and today I would like to tell you about draft law 5067 that was submitted to the Supreme Council. So starting from the 1st of January this year, Commission was started to review complaints, and you know that it's impossible to review these cases without proper work of registrator, and we studied all radar schemes that are used by offenders in our country, and then we created a working group. We discussed firstly these radar schemes, and secondly we developed a draft law that stops these schemes. And I would like to tell you more about these 13 changes that are envisaged by this draft law, and also to say why the adoption of this law is absolutely necessary today. First radar scheme that existed starting 2002, registration of property right on the fake ruling of court. And now there is proper correlation between the register and the ruling of courts, and when this coordination will be started, it will be technically impossible to register based on fake ruling of the court. And at the same time, we understand that technically the cooperation of these registers is difficult because the register of court decisions is not ready for this coordination. That's why the draft law envisages the norm according to which if the notary gets the decision of the court, the notary of state registrator should verify whether this decision is in the court register. If the register does not see this in court register, it should take decision to stop registration and to address officially to the court with the claim that the court provided a copy of the decision, and after getting this letter, and if the decision of the court is true and not fake or falsified, only after this registration will be carried out. So this scheme existed starting 2002, and now this draft law will stop this violation. And also criminal responsibility will be reinforced. The criminal activity can be punished up to 8 years, and also those persons who are involved in radar attacks, we envisage the norm that introduces criminal responsibility for the violation of the sphere of the document, and this is Article 205, and we introduce the norm. And when the law will be adopted, state registrators can be brought to criminal responsibility for faking the documents, and also the claimants, they are responsible for the validity of the documents that they brought to registrators, and also those who execute all these actions. And also one more important change is connected with the sphere of business. Now, in order to carry out registration of the change of members of the union or joint stock company, so now there is no notary verification, and this draft law introduces the norm that there should be meeting of the participants, of the stakeholders, and then if some representatives leave or new members come, then this should be signed by the secretary and participants, and the head and the secretary signatures should be notified by notary, and it should be introduced in the statute if the members take appropriate decisions on introducing of changes in the statute of the organization. And business awaits for this change, for this norm, for a long time, and there was draft law 4216, but it wasn't voted for. That's why this draft law 5067 and this draft law we introduced this norm, and we introduced such a norm that the signatures on protocol and statute should be checked and notified by notary. So, in some cases, raiders address state registrators, and if there is some real estate that is registered, and this is the right of real owner, they are opened new entry and registered the property for another person. And knowing such a scheme, we envisaged in the draft law the norm that stops these actions, so there can be two entries at the same time. One more thing that is of importance in the media, they said that the register was broken and the hackers interfered in the activity of the site and got the keys of state registrators, and at night they register some businesses and property. By this stolen keys, the registers, they were not violated. There were some cases of those attacks when too many requests were sent to state enterprise, and because of these attacks, maybe for 24 hours or more, the registers were not operating, but our sites were not violated. Yes, hackers really violated the registers of notaries and carried out registration through with the use of these keys, and then the notary came to the office and saw that some actions were carried out on behalf of them, and they addressed to national police with a requirement to stop and turn out this electronic key. And knowing this, we envisaged the norm according to which the electronic key will be exclusively on a separate carrier, that it is done in Europe, and this will allow it will prevent to get this key, and if the computer is broken, the key that is on the separate technical carrier, it will be impossible to get this key through this computer. So in other words, if someone steals this key, he needs to do this physically get this key, and there were no such cases. One more important aspect, we also, in this draft law, we envisaged control and monitoring functions of the Ministry of Justice. So if, for example, there will be an address and some information will be gotten from law enforcers that some registrator carry out registration actions illegally, we can monitor these actions and verify them. And if we see that there were some faults or violations by registrator, the draft law envisages that in this case the Ministry of Justice provide this information immediately to all stakeholders that have relation with this facility, and then they send this information to law enforcement bodies. And now the control functions of the Ministry of Justice are narrowed to that it can verify the complaints on state registrator. If there is no complaint, the Ministry of Justice cannot do anything. So we envisage this control and monitoring functions, and the result of this function will not be bringing someone to criminal liability, but informing law enforcement bodies and interested stakeholders that something is going on. And if interested parties will get information that their rights are violated, then the stakeholders can address to commission that will review the complaint. And one more important change, we narrow extraterritorial principles. You know that now, when we are speaking about state registration and the regional administrations or accredited entities, they can carry out registrations in the framework of the oblasts where they register. At the same time, the notary, on the principle of extraterritoriality, they can carry out these actions throughout the country. That's why we decided that we should give the same rights to all state registrators. That's why the notary will have also limited to the territorial areas, the oblasts, and the exception from this rule if the notary carry out some notary actions concerning, for example, heritage. So the principles of extraterritoriality will act. And in the sphere of business now, the principle of extraterritoriality, we narrow this principle also to the oblasts, but only in the case if registration is carried out based on paper documents. If business wants to carry out a registration online through electronic signature, so principle of extraterritoriality will be enforced. We are limited in time. The draft law also envisages important changes. And you can find this draft law and you can read it. And we have many publications as to this draft law. You can find this information in free access in the network, and you can know more about it. We increased the term during which the person whose rights are violated can address the Commission, and this term is now 30 days. And we will have 60 days now because there were many complaints that were not properly formed, and when we say to those who complain that there are some violations, some errors, so they correct these errors and they address to Commission once again, but the Commission reject their claims because the terms are violated, the term of 30 days. And in order not to deprive real people who complain to defend their rights, the term was extended up to 60 days. And once again, I state that you can find this draft law. It is really important for our country now because we all know that the issue of defending of the rights of private property for those facilities our citizens own and business owns as the priority number one of our state, and by this draft law we reinforce this right and prevent raid attacks in the future. And I'm convinced when the law will be adopted, the number of radar attacks in our country will significantly drop. And on Wednesday, last Wednesday, there was a Profile Committee meeting, and this draft law was delayed, it was blocked, and we immediately responded on this in the media. They started to campaign on this. They conducted roundtable on Thursday, yes, and also on Wednesday. Yesterday, I had a press conference, and I hope that this draft law will be in the Profile Committee once again, and next week on Wednesday. And I hope that Profile Committee will approve this draft law in the form it now exists, and will provide it to the Parliament in order that the deputies would vote for this and take it in the first reading. So, there are maybe small drawbacks, but I invite everyone to join this initiative, and by all means that you have to bring this case to its logic end and convince the deputies and the Profile Committee that this draft law 5067 is very important to adopt now. Thank you very much. Thank you, Pavel. Do you have questions? Yes, I see the question. Please introduce yourself first.
The administration of the central police apparatus, how many complaints did you have and how many satisfied people did you have after that? I'd like to know the number of figures and companies who apply. Are they small or medium-sized enterprises? First of all, the number of complaints. The number of complaints, that is, the documents called as a complaint. There are more than 1,000 of these complaints, but most of these complaints were transferred into applications because they were not admitted to, they were accepted to consideration because of some formal indications. If you talk about complaints who were accepted to the Commission, the number is about 300, and 200 complaints were satisfied. But in terms of complaints that were not satisfied, we may say that this doesn't mean that the Commission didn't help the applicants, because there are some complaints applied by raiders using this tool and intending to cheat the Commission and to do some raider deals with this Commission. There were some business and real estate complaints, and the ratio is 80 to 20. 80 means real estate and 20 refers to businesses. The best protection is to make registers open for public, because there are some not decent notaries who hide information and who take money for sharing this information. It's very important for legal entities and individuals who would understand better how to protect themselves, and this will protect people against indecent notaries. I share this opinion completely about the registers, that they should be open to public. Of course, the real estate registers are open to public today. Now we are considering an opportunity to open the corruptioners register and the register of power of attorneys. They will also be open. And about innovations stipulated by law 5067, we give access to notaries, but in the read-only mode about Civil Act documents. They also insisted upon this success. There were some misuses in this area. The register of civil acts are not open because they have some personal data, they keep some personal data, but we provide the notaries access to these registers in the read-only mode. We understand that the notaries will use these registers only in case when they will have to deal with sharing property or about heritage. We are finishing this conference. See you later. Thank you. Dear colleagues, we will have the next event in 5 minutes.